Welcome back to Beyond Borders, the podcast that breaks down the complexities of U.S. immigration law into clear and actionable insights. I'm your host, Gianni, and today we're diving into two of the most sought-after visa categories for highly accomplished professionals and individuals, the EB-1A Extraordinary Ability Visa and the EB-2 National Interest Waiver. Whether you're an artist, scientist, entrepreneur, or academic, these pathways could be your ticket to permanent residency in the United States. Let's get started. First up, let's dive deep into the EB-1A Extraordinary Ability Visa, a category often called the talent visa, for good reason. This visa is designed for individuals who are at the pinnacle of their fields. Think Nobel laureates, Oscar award winners, groundbreaking researchers, and world-renowned artists. This EB-1A is all about celebrating extraordinary talent and allowing it to flourish in the United States. Here's what makes the EB-1A unique. Unlike other employment-based green cards, you don't need an employer to sponsor you. That means you can self-petition if you meet the high standards required. So, how do you prove you're extraordinary? The law lays out 10 regulatory criteria, and you need to prove at least 3 of them. Let's unpack a few examples. One example is awards. So have you won any awards and major prizes in your field? This could include anything from a Pulitzer Prize to internationally recognized industry awards such as the Grammys or Latin Grammys. Media recognition. Have you ever been the subject of published material in professional or major trade publications? Maybe you've been featured in Forbes, the New York Times, or Billboard magazine for your outstanding work. So it's important to know that the major media should address your accomplishments and should mostly be about you. And any articles that merely mention you don't hold much weight for USCIS purposes, for immigration purposes. Another example is judging. Have you been invited to serve as a judge or panelist to evaluate others in your field? For example, if you're a singer and served as a judge in your country's nationally recognized singing competition, or if you're a researcher and you've served as a panelist or evaluator for thesis at a university. This could definitely be a sign that your expertise is second to none. And another example is original contributions. Have you made groundbreaking contributions to your industry that have a significant impact? Have others adopted or your innovations? Have they been trademarked and patented? If you're sitting there thinking, well, that sounds intense, you're not wrong. The EB-1A is a high bar to clear, but it's entirely achievable with the right approach. The key is not just what you've accomplished, but how you present it. USCIS not only wants to see a list of accolades, but also a clear narrative of how those achievements showcase your extraordinary ability in your field. So let's talk strategy. Applying for an EB-1A isn't about checking all the boxes. It's about painting a compelling picture of your expertise. Here are some tips to make your application stand out. Number 1, document everything from press articles to award certificates. Every piece of evidence counts. So make sure you're thorough in gathering documentation. Number 2, focus on impact. Don't just list your accomplishments, explain why they matter. How did your work change your field or influence others? Number 3, leverage expert support. Letters from recognized experts in your industry can bolster your case, especially if they detail your contributions and their significance. These type of letters are extremely detailed, especially for the EB-1A that has such a high standard. And number 4, anticipate scrutiny. Be prepared for requests for evidence and address any potential weaknesses in your application or your petition upfront. One common mistake I see applicants doing is underselling themselves. So don't assume USCIS is connecting the dots. You need to spell it out for them. You need to do it for them. So for example, if you've developed a technology that is used globally, explain its adoption rate, the industry it impacts, and how it's revolutionizing the field. Okay, so now let's pivot to the EB-2 National Interest Waiver. This option is for those who don't necessarily meet the extraordinary ability standard, but still have exceptional qualifications or an advanced degree. So the key difference here is the focus of how your work benefits the US as a whole. So let's start with the requirements. To qualify for an NIW, you must show that you have an advanced degree, which is a bachelor's degree plus 5 years of post-baccalaureate experience, or a master's degree or higher. or that you're an individual with exceptional ability. Exceptional ability in the context of the EB-2 NIW refers to a level of expertise that is significantly above that is ordinarily encountered in the field. It applies to individuals whose skills, achievements, and experience make them uniquely qualified to contribute to their field of expertise and by extension to the US economy, culture, or welfare. To qualify as having exceptional ability, an applicant must meet at least 3 of the following 6 criteria. Degree, diploma, or certificate. So documentation of a degree, diploma, or certificate, or similar award from a college, university, or institution relating to the area of exceptional ability. You must have experience and expertise, so letters from current or former employers documenting at least 10 years of full-time experience in your field. Professional licenses or certification, a license, for example, to practice in the profession or certification for the profession or occupation. Number 4 is a high salary or compensation. So evidence that the individual has commanded a salary or other remuneration demonstrating exceptional ability compared to others in the field. Another criteria is professional association of membership. So membership in professional associations in your field, which often require significant achievement or contributions for admission. And the last criteria is recognition for contribution. So evidence of recognition for achievements and significant contributions to the field by peers, government entities, or professional or business organization. If you cannot meet the exact criteria I previously mentioned, you can still submit comparable evidence to show your exceptional ability in your field. And this examples include patents, proprietary techniques, innovations in your field, leading or starring role, major media publications, or awards demonstrating unique contributions. So unlike a standard EB-2 visa, the NIW waives the job offer and labor certification requirements if you can meet the DANASAR 3-prong test. That is, number 1, that you can show that your project or proposed endeavor in the United States has substantial merit and national importance in the field. So you have to show that your field of expertise and the specific concrete project has significant value, whether it's cultural, economic, scientific, and will benefit the US broadly and specifically in the field. The second prong of the DANASAR test is that you are well positioned to advance your proposed endeavor. And all those pieces of evidence that I listed before, such as major media, awards, letters from professionals in your field, all of those can be used to show that you are well positioned to advance that specific project here in the US. And the last prong for the DANASAR test, waiver of the labor certification, is in the US interest. So here you have to demonstrate that the petitioner's work benefits the US enough to forego the labor certification process. And USCIS tends to look at different factors. For example, you need to prove that there are no US workers available for the job, meaning there's a shortage, or the fact that the project or proposed endeavor is in the national interest is another factor that they tend to look at. So I wanted to go over some practical examples of exceptional ability. So one would be an economist whose research leads to actionable policy improvements benefiting US economic stability. Another example could be an engineer developing innovative technology that revolutionizes renewable energy infrastructure. And another example could be a medical researcher addressing a public health issue, such as developing advanced treatments for chronic disease. So you might be wondering, how do you choose between the EB-1A and the EB-2 NIW? Well, it depends on your credentials and your career goals. So if you have a long list of accolades and can demonstrate international or national acclaim, then the EB-1A might be your best bet. If your work is impactful but doesn't quite reach the extraordinary threshold, the EB-2 NIW provides a more flexible path for you. Both categories require meticulous documentation and strong legal strategy, and that's where having an experienced attorney can make all the difference. I've seen cases where a well-crafted petition transforms an applicant's prospects, turning what seemed like a long shot into an approval. So before we wrap up, let's revisit trends and policies we've seen under the previous Trump administration, as they will likely provide a blueprint for the upcoming one. So immigration policy under the Trump administration, the first Trump administration, historically prioritized scrutiny and enforcement as well as STEM fields. For the EB-1A, Heightened scrutiny of extraordinary ability claims was a hallmark. USCIS increased the issuance of requests for evidence or RFEs, demanding more detailed proof of applicants' achievements and requiring expert opinion letters to substantiate claims of extraordinary ability. So applicants tend to face a higher bar for demonstrating how their work provided immediate and tangible benefits to the US economy. The EB-2 NIW category also faced challenges. Approval rates dropped significantly due to the more rigorous approach or interpretations of national importance and substantial merit. So applications with insufficiently detailed future plans or vague claims about their impact were often denied. And that's something that has continued under the Biden administration. RFEs frequently questioned whether the proposed work was essential on a national scale, emphasizing the need for more applicants to create highly specific and data-backed petitions. So looking ahead, we can expect renewed delays in premium processing for certain categories and stricter adjudication standards across the board. Past Trump policies also targeted the deference policies, which required adjudicators to assess petitions without reliance on prior approvals or decisions, which further complicated the process at the time. To navigate these challenges, applicants should focus on submitting robust, well-documented cases that clearly align with national priorities like the STEM fields, healthcare, renewable energies, as some examples. It's also important to recognize that the Trump administration places a lot of importance on business and the economy. And that's exactly what we're doing with the EB-1A and the EB-2 NIW. We're attracting global talent here to the United States to contribute to the economy. That's all for today's episode on Beyond Borders. If you're considering applying for an EB-1A or EB-2 NIW, or you just want to learn more about these incredible opportunities, feel free to reach out. My team and I focus on business immigration, and we'd love to help you on your journey. Don't forget to subscribe, leave a review, or share this video with anyone who might find it helpful. Until next time, I'm Gianni, and this is Beyond Borders.